Hello, everyone. Today, as part of my intellectual property rights management assignment, I shall be going through a detailed exploration of five landmark judgments by the Allahabad High Court that dissect critical aspects of trademark law in India. These cases span issues like deceptive similarity, surrogate advertising, ownership disputes, and the intersection of trademarks with public policy. My goal here is to unpack how courts interpret the Trademarks Act 1999 and how they balance competing rights and set precedents that shape India's intellectual property landscape. Let's begin by understanding the framework of this analysis. Trademark law at its core protects brand identity, prevents consumer confusion, and fosters fair competition. The Trademarks Act 1999 espouses certain principles such as distinctiveness, infringement, rectification. The objective of this analysis is threefold. First, examine judicial interpretation of deceptive similarity and passing off. Second, assess how courts handle trademark ownership disputes. And third, critique the balance between trademark rights and public interest. Let's dive into the first case where trademarks become tools for circumventing liquor advertising bans. In the case of Struggle Against Pain versus State of UP, the facts of this case were the liquor brands like Royal Stag and McDowell's advertised non liquor products such as mineral water, CDs, etc., using their liquor trademarks. The petitioner argued that this violated Section 3 of the UP Intoxicating Liquor Act 1976, which bans ads promoting liquor consumption. The core issues were 1. Can trademarks be misused to indirectly promote prohibited goods? And second, does such use dilute the legislative intent of public health laws? The court's reasoning was that the High Court held that surrogate ads were designed to maintain brand recall for liquor, not to genuinely market alternate products. Tra- It, the court said that trademarks cannot legitimize indirect promotion of banned goods. The court prioritized public health as per the directive principle of state policy, Article 47, over commercial speech, which is Article 19(1)(a) under the Constitution. This High Court's reasoning sets a precedent that trademarks must align with statutory prohibitions. It reinforces that courts will look beyond literal compliance to assess intent and public harm. To quote the judgment, surrogate ads are a wolf in sheep's clothing. Their true purpose is to keep liquor brands in public memory. The second case is Kapila Krishi Udyog versus Kamdhenu cattle feeds, where the dispute was about ownership. A family feud over the trademark Kapila Pashu Ahar for cattle feed was existing. The registrar transferred ownership to the appellant under Section 45, but the respondent challenged this via a Section 57 rectification petition before the IPAB. The core issues of this case were 1. When should courts grant injunctions in ownership disputes? And 2. How do Sections 45, which is related to transfer, and 57, which is related to rectification, interact? The court's reasoning was that they refused an interim injunction directing parties to resolve ownership through the IPAB. The court's key legal principle was that specialized tribunals are better equipped to handle technical trademark disputes. Civil courts should avoid parallel proceedings. This highlights the importance of tribunal primacy in complex ownership cases. It emphasizes that interim relief under the CPC Order 39 must not undermine statutory remedies, such as under Section 57. While procedurally sound, this approach risks delays, leaving aggrieved parties without urgent relief. Therefore, trademark ownership battles demand patience and reliance on expert tribunals. The third case is India Glycols versus Radico Khaitan. Radico Khaitan, owner of the Magic Moments vodka trademark, trade dress, which included bottle design and the label, alleged that India Glycol's Amazing Vodka copied its distinctive packaging. The trial court granted an ex parte injunction under CPC Order 39. India Glycols appealed immediately, bypassing the procedural step of filing a vacation application. The core issues were 1. How does trademark law protect trade dress, which is defined under Section 2ZB? The second issue is, are ex parte injunctions justified in blatant infringement cases? The High Court dismissed the appeal, stressing strict adherence to CPC procedure. Procedural compliance, such that is Order 39 Rule 4, cannot be bypassed even in urgent cases. Trade dress is therefore protected under trademark law, but procedural rigor is sacrosanct. Risks delays, which may embolden infringers, but due process ensures fairness. Contrast this with US law, where preliminary injunctions are granted faster under the eBay versus Merck exchange four-factor test. To quote the judgment, law's machinery must grind methodically, even when urgency knocks at the door. The fourth case is Subhash Chand versus Mahesh Chandra. Subhash Chand, owner of Panchi Petha store, which has been trademarked since 1973, sued competitors using new Panchi Petha store. The trial court dismissed the suit, ruling that new distinguished the marks. The High Court reversed this. The core issues were, does adding a prefix like new negate deceptive similarity under Section 29? And two, how does the Cadella test apply to common law passing off claims? The High Court applied the Cadella Healthcare versus Cadella Pharmaceuticals test. The overall impression matters, not dissected elements. Consumer confusion is likely when marks share dominant elements, such as punchy Petastro. Minor additions don't override deceptive similarity. This strengthens protection for well known marks against cosmetic exchanges. It affirms that consumer perception, not technical tweaks, drives infringement analysis. The last case we shall be discussing is Apex Labs versus K. Prasad Reddy. Apex Labs used a green dot symbol mandated by food safety laws on its Zincovict syrup. Competitors claimed copyright over the symbol. The first issue was, can statutory symbols such as the green dot be trademarked? And two, how does Section 9(1)(b) limit trademark registration? The High Court ruled that public domain symbols cannot be monopolized. Trademarks must be distinctive as per Section 9(1)(b). Mandatory symbols lack distinctiveness and serve public health, not brand identity. This prevented the misuse of trademarks to control regulatory compliance tools. It aligns with TRIPS Article 17, which permits exceptions for public interest. It is similar to the US rejection of trademarking the R symbol or the trademark symbol. Let's synthesize these cases into three pillars of trademark law. 1. Deceptive similarity and consumer confusion. Subhash Chand and India Glycols showed courts prioritize overall impression over minor differences. 2. Ownership and rectification. Kapila Krishi underscores APAP's role in resolving technical disputes. 3. Public interest limits. Struggle against pain and Apex Lab proves trademarks cannot override health or regulatory goals. Therefore, the critical question is, how can India balance speedy enforcement with procedural fairness? There are certain strengths that can be analyzed from these cases. The first is doctrinal rigor. Courts consistently apply the Cadella test for deceptive similarity. The second is tribunal deference. Kapila Krishi, for example, respects IBAB's expertise, avoiding forum shop. The third is public welfare focus. Courts curb trademark misuse in surrogate ads and public symbols. However, there are certain critiques and gaps that can be seen. The first is procedural delays. India glycols show strict compliance can harm trademark holders. The second is underused proportionality. Courts rarely balance IP rights with public access, unlike the EU's three-step test. Third is ambiguity in surrogate acts. There are no clear guidelines under the Trademark Act for indirect promotions. Should India adopt a preliminary injunction model similar to the US to address urgency? There are certain recommendations for reform as well. To strengthen India's trademark regime, I propose 1. Expedited injunction hearings. 2. Guidelines for surrogate advertising. 3. Proportionality in relief, where we should borrow EU's enforcement directive, balance IP rights with third party interests. 4. Is public trademark databases. And the fifth is judicial training modules. Workshops on Section 29, 45, and 57 with case studies from global jurisdiction will really help develop India's trademark sector. It matters because a robust trademark system fuels innovation, protects consumers, and aligns India with global standards like TRIPS and the Madrid Protocol. In conclusion, these Allahabad High Court cases reveal trademark law as a dynamic interplay of rights, procedure, and public interest. While courts have commendably safeguarded distinctiveness and deferred to tribunals, procedural delays and gaps in addressing surrogate ads demand reform. The path forward lies in blending India's doctrinal rigor with global best practices, ensuring trademarks remain symbols of trust, not tools of deception. As Justice Krishna Iyer once said, law is the tool of social engineering, and trademark law must balance innovation and integrity. Thank you very much for listening to